stopped, instructed to stay, and were kept from leaving, Judge. They were questioned and were asked to perform the field sobriety test, Judge. Specifically, Trooper Edwards describes Mr. Hobbs as being handcuffed after the fact, searched, placed in the front seat of the patrol unit, and secured. He was given a DIC recording, the trooper describes, which of course, Your Honor, begins with the sentence, "You are under arrest." The BAC report was available shortly after in December, Your Honor, so it wasn't a long time before the report was available. And so at that point, nothing else was keeping the straight from moving forward with the prosecution of this case. Prosecution would have been possible and should have happened no later than that, Your Honor. The complaint, as you mentioned, Your Honor, was filed October of 2022, 1 month shy of the statute of limitations running out. And Judge, nothing in my review of the file suggests that there was anything justifying the delay. Your Honor, the defense argues that the length of the day is presumptively prejudicial, Judge, almost coming close to the statute of limitations. Nothing at all, again, Your Honor, appears to justify the delay. Mr. Hobbs did not contribute to, nor did he acquiesce to any kind of the delay, Judge. He has asserted his right to a speedy trial. And Your Honor, the delay has prejudiced my client's ability to go forward with a fair trial. It's my understanding that some of the co-defendants are from out of town or are no longer in town, Judge. And not only that, but just his memory of the events, obviously, given the time that has lapsed, is just something that doesn't allow for what I believe a trial that would be fair to him.
And are you going to put your client on for I guess, to testify in regards to how this has affected, the delay has affected his ability to put on a case?
No, Your Honor.
Okay. So that's it?
In summary, Judge, yes, Your Honor. We have a memorandum prepared that I don't believe we have filed yet that we can submit to the court as well, Judge, but that's essentially the outline of it.
Okay. Let me hear from the state.
Thank you, Your Honor. So ADA Miguel Hernandez has filed an answer, which I believe sufficiently responds to defense counsel's motion. We begin the question by, does this situation invoke the Barker-Wingo analysis? And the first step in that process is the length of delay. And if it does not reach a point of presumptively prejudicial, we stop there, do not pass go, do not collect $200. So the question then becomes, well, what is that relevant time here? Defense counsel makes reference to the offense date of November 27th, 2020. That is, however, not the relevant trigger point for the analysis. The relevant trigger point is at which point in time the defendant became accused. Now, that can be triggered by one of two events, whichever occurs earlier in time, whether formal charges are brought or whether the arrest takes place. For most misdemeanor cases, we're usually going to have the arrest take place first. In this instance, that is not the case. So the triggering event is the filing of the formal charges, which was October 21st, 2022. Defendant was not arrested until December 2nd, 2022. And although that latter date would be more advantageous to the state in this particular hearing, that would not be the appropriate triggering event. The appropriate triggering event would be the filing. So that leaves us at October 21st of 2022. That from that point to today, we are in the beginning of May. This is the end of October. So November, December, January, February, March, April. We're only at the 6-month period. That does not cross the threshold of being presumptively prejudicial. Therefore, we go no further into the Barker-Wingo factors. I would leave the state's position there unless the court would like me to address some of the other factors if the court first makes the finding that the delay is presumptively prejudicial.
I have read cases, and I cannot cite them to you like right now. I'm sure I have them somewhere here, where the triggering event is the actual, I guess that, well, he wasn't arrested, so that kind of complicates things, right. But the date of offense. So let's assume that the triggering event is the date of offense. So what else do you have? That way we don't have to come back. Sure.
So let me just address that for purposes of the record, the state's position. Yes. The offense date is not the triggering offense. I believe what the court is referring to would be cases, and we see them frequently in our misdemeanor courts, wherein the offense date and the date of arrest are the exact same date.
Mhm.
And in that case, the reason why the offense date is the triggering date is not because it is the offense date, but because it's the date of arrest, and that's what invokes the individual becoming quote unquote accused. So moving forward from that, then the second Barker-Wingo factor is the reason for the delay. Well, here in time, there's so short of a passage of time from when the case was filed to where we are today that the filing was October 21st, 2022. Well, actually, let me address in two parts, because we are responding to the court's request that we make an analysis based on the offense date, independent of the fact that it was not also the arrest date, that there's no other triggering event taking place on that day.
Mhm.
So to address that initial period in time between offense date of November 27th, 2020, and the next arguable triggering date, which would be the filing date of October 21st, 2022, I would submit to the court or I'd ask the court to take judicial notice of the Texas state emergency orders that were in place, beginning with emergency order number 43, which was filed on issued on September 21st of 2021 and extended all the way till March 1st of 2023. During that period in time, there was a very narrowing of the availability of trials because they were either suspended entirely, or as those emergency orders evolved, they did allow for trials, but they allowed for trials under very specific constraints. Those constraints resulted in very few trials being had. So I would state that for the failure for any trial to have taken place during that period in time, it's a non-issue because there weren't any trials taking place during that period of time. And I believe it would not be inappropriate to ask the court to take judicial notice of its own docket in seeing how many trials have been held in this court during that time. There wasn't but so many seats available at the table. So subsequent to the filing date, then I think that takes us back to what we're arguing is the relevant period, which is from filing date October 21st to now. And in that period in time, the first court date that was set by the court, which is outside of the control of the state, was the discovery compliance hearing on March 1st, 2023. The motion to dismiss for lack of speedy trial was filed 5 days later. So there is no period in time with which to provide a reason for. After the very first court date that we had here, the motion was immediately filed asking for dismissal. The third Barker-Wingo factor is whether or not the defendant asserted his right to a speedy trial. And here he did not. There is no demand for speedy trial filed. The first voicing of the concern happened with the filing of the motion to dismiss for a lack of speedy trial. It is the constitutional right of the defendant to have a speedy trial. There is not the constitutional right to the dismissal of the charges. The dismissal of the charges is an extraordinary remedy only to be invoked when the constitutional right has been violated. That has not happened in this case. Final Barker-Wingo factor is the prejudice to defendant. Again, this is the defense's burden to present to the court sufficient prejudice to invoke that extraordinary remedy. And here there has not, and we have to be specific. Speedy trial is concerned when reference to prejudice, to the prejudice of the defendant's ability to defend the criminal accusation at a trial. So any other considerations, such as, conditions of the bond he was on, things that might be an inconvenience, while inconvenient, are not the prejudice that we're referring to. So defense counsel cites the prejudice has been defendant's own memory and that other potential witnesses have left town. Those prejudices, should the court find that they exist because of the independent actions of other parties, of those witnesses, the defendant's own recollection of the events. They are not due to the passage of time, which is the cause for the prejudice that speedy trial is concerned with. For those aforementioned reasons, the state would first make the argument that the Barker-Wingo analysis is not properly invoked in this instance because the length of delay is not presumptively prejudicial. That is based on the argument that the triggering event in this instance would be the filing date of October 21st, 2022. If the court does not make that finding and makes the finding that the appropriate trigger date is the offense date, I have proffered arguments as to each of the subsequent Barker-Wingo factors in light of that hypothetical.
Okay,
Commission, to
Go
briefly
ahead,
respond, Your
Mr.
Honor.
Parra.
Thank you, Your Honor. With respect to the state's argument that the triggering point should be when the complaint is filed, I mean, that essentially is an argument that would allow for the state in other cases to wait until close to the end of the statute of limitations, allow for that prejudice to take place, allow for evidence to be less available, Your Honor, allow for less access, I suppose, to being able to present a fair defense on any kind of a client, and then just say, oh, well, too bad, no speedy trial argument because we decided to delay the prosecution of the case. We are the ones who held back on filing this case when we could have done so much sooner. Your Honor, with respect to the arrest, Judge, I would argue that he was effectively arrested the day of the incident. Again, as per the DIC recording that he listened to that the trooper played, he was under arrest. He was handcuffed, Judge. He was not allowed to leave, even though perhaps probable cause was not issued until much, much later, Your Honor. He was, in my opinion, very much under arrest at the time. And I would argue that that in itself should make it so that that's the triggering point.
Let me ask you this.
Sure.
You say he was read the DIC. Was his license suspended? Did DPS send any type of notification?
Your Honor, DPS did send a notification, Judge. We were able to keep his license from being suspended, leading to an ALR hearing.
Can you explain that a little bit more?
Yes, Your Honor. We requested shortly after the incident an ALR hearing, Your Honor. Eventually, DPS dropped it.
Okay.
So his license was not
So
suspended.
DPS did send out basically a letter to Mr. Hobbs saying, based on the fact that an alleged DWI was committed, or what was the reason for the suspension? Was it was a blood draw, right?
This was a blood draw, yes, Your Honor.
Okay, so what was the reason that DPS was going to suspend his license, if you remember?
Your Honor, my memory is just that they believed that the trooper was sufficiently going to testify that he was operating a vehicle under the state of intoxication. I believe that by the time that we were scheduled anyway for the ALR hearing, the blood results had already been available. But again, it was the DPS who decided not to go through with it. His license was not actually suspended.
Okay, go ahead, sorry.
No, thank you, Your Honor. Now, with respect to the emergency orders, yes, Your Honor, I understand that there were no trials that took place, but I mean, that doesn't address why there wasn't any kind of a filing of the case, Judge. And 23 months after the fact, when everything was available 1 month after the date of the incident, in my mind, nothing justifies that, Judge. And here we are much later. I think that there's a presumptive prejudice given how long has passed, Your Honor. I mean, the delay itself makes it, I think, almost impossible to pinpoint what could have been available or might have allowed for a more fair trial, Judge. And at this point, it's not just a matter of his not being able to recall, should he decide to testify, and anything that might have done, well, whether or not the witnesses on their own left El Paso, Judge, and are no longer available to testify, that's something that wouldn't have happened if this had appropriately been filed within a reasonable amount of time. I would have been able to find that witness information, perhaps get some kind of investigation going on, get some statements going, Judge, and now that's unavailable to Mr. Hobbs.
And just so that the record is complete,
Yes,
in
Your Honor.
case it is appealed, I know I did try 2 jury DWI cases during COVID. I do not have the exact date. I don't think it was, I think it was in 2021, if I'm not mistaken. Mel, do we have or Mary, do we have the exact dates? Because I know we did try 2 or 3 cases during COVID. I cannot give you the exact dates.
Find out for you if you give me a few.
Okay, let's, a few minutes. That way the record is completely complete.
Not just complete, but completely complete.
Very completely complete.
Can't get any more complete than that, Judge.
Okay, so we had a trial on October 26, 2021, and another one on November 16th, 2021.
Okay. Alrighty, go ahead, Mr. Parra. And these were jury trials, DWI with verdicts, if I remember correctly.
That's correct, Judge.
Okay, go ahead, Mr. Parra.
That was it, Your Honor. And for the above reasons, we request that the court grant this motion.
Okay, this is what I'm gonna do. Since this is one of those cases where it doesn't fit the facts of the other cases where the person was arrested the day of the offense, that would have made it simpler. It's one of those unique cases. So I'm gonna give you 1 week. I'm gonna research, and then if you want to send me any cases that you want me to look at, you've got until next Friday to send me cases. If you are gonna send me cases, make sure you copy opposing counsel.
Understood, Your Honor.
Okay? All righty. Anything else?
Nothing further from the state, Your Honor.
Nor the defense, Your Honor.
Okay, all righty. Thank you so much. Have a great day.
Thank you, Judge. Mr. Hobbs will be in touch